Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of person ineligible to act as a resolution applicant. Even in the previous class also, we have discussed the person who is ineligible to act as a resolution applicant. Continuing that, today also we are going to discuss the person who are ineligible to act as a resolution applicant. Now, in this class, today we are going to discuss each and every class along with the judgments. Okay, so these two classes we have to read together. Okay, so that means section 29A we have discussed in the previous class as well as in this class. Okay, so you have to go through these two lessons together. Okay, so section 29A, as already we have discussed in the previous classes, section 29A deals with persons who are not eligible to be resolution applicant. Okay, now let us discuss judicial precedents. Okay, section 29A includes person acting in concert jointly or in concert with such person. Okay, so then what is the meaning of person acting jointly or in concert? So in the case of ArcelorMittal India Private Limited versus Satish Kumar Gupta, the Supreme Court held that the term, okay, because section 29A they have used the word terms acting jointly, acting in concert. Okay, so these terms expand the scope of section 29A because section 29A does not include only the person. Section 29A includes person acting jointly, person in concert. Okay, so from where we have to refer the meaning of person acting jointly, person acting in concert. So in the case of ArcelorMittal India Private Limited versus Satish Kumar Gupta, Supreme Court held that, okay, so you can refer the definitions or the meaning given under the SEBI SAS regulations. Okay, so it is also called as takeover code. Under the takeover code, okay, so we are having a broad definition for person acting jointly, acting in concert. Okay, so whenever you are interpreting acting jointly and acting in concert under the IBC code, you may refer takeover code. So in another case law, Rajdeep Clothing and Advisory Private Limited versus Brijesh Kumar Mishra RP of Krishna Knitwear Technologies Limited. So in this case, NCLT Ahmedabad bench held that the object of section 29A is to bar the CD from going into hands of person who is responsible for the indebtedness and mismanagement of such CD. So what is the basic object of section 29A? So in this judgment it was held that, so under section 29A certain categories of people are considered to be ineligible. So who are all these categories? So these people actually they are there in the management of the company, that is CD. So already they were there in the management of the company and they are the people who are responsible for this indebtedness. So that's why, so the basic object of this section is that the person who is actually responsible for the indebtedness or mismanagement in the corporate debtor, so once the CRP process is started, he cannot again file an application or file a resolution plan to acquire the company at a cheaper prices, whereby haircuts are more, haircuts can be more. So this IBC code cannot be used to get the company at a cheaper prices. Okay, so that is the basic objective of this section. Okay, so in this judgment it was held that section 29A is clearly imposing a bar on the persons actually who are responsible for the mismanagement and indebtedness of the corporate debtor. So that is the basic purpose of section 29A. So that's why they are including person acting jointly, person acting in concert. So that is the basic purpose of including not only the person acting in jointly. Okay, then let us discuss further section 29A subsection clause A. So prospective resolution applicant is an undischarged insolvent. So in the previous class we have discussed the section. Now we are discussing the interpretation. Okay, so one of the category of the person who is not eligible to be resolution applicant is that undischarged insolvent. So then what is the meaning of undischarged insolvent? So in the case of Tampanur Ravi versus Chaurupara Ravi, so in this case the Supreme Court held that the term undischarged insolvent must be interpreted in the terms of Provincial Insolvency Act 1920. So we are having various legislations dealing with insolvency in relation to the individual in India, like Presidency Town Insolvency Act and Provincial Towns Insolvency Act. So under the Presidency Town Insolvency Act and Provincial Towns Insolvency Act, we are having definition for undischarged insolvent. So what is the meaning of undischarged insolvent? If any person files an application, files a petition for declaration of insolvency, then the petition will be admitted by the DRT. Then subsequently, the liquidator will be appointed, receiver will be appointed in case of individual. Then he is going to sell all the assets of the person. Then he is going to clear the debts. So even after paying the money, if the amount is not sufficient, that means his debts are not totally clear, then such person is considered to be undischarged insolvent. In the subsequently, there is a possibility he may clear the debts and he may get the status of discharged insolvent. Okay, there is a basic concept of undischarged insolvent. So until you clear the entire debts, you are considered to be undischarged insolvent. So that is the meaning that you have to take when you are interpreting section 29A. So if any person is undischarged insolvent, he cannot be resolution applicant. So in another case, Gulshan Kumar, proprietor of Gulshan Trading Company versus Bandari Deepak Industries Private Limited. So in this case, NCLT Chandigarh bench held that a company, even MSME, cannot by itself apply to act as a scheme proponent where it is undergoing liquidation. So suppose if any company is there, there are certain exceptions are there to the MSME, but still, even though exceptions are there, but if any company is undergoing liquidation, okay, they are considered to be undischarged insolvent because the process of insolvency is going on. Okay, it is not yet settled. So that's why if any company is undergoing the concept of liquidation, in such cases, such company is not eligible to be resolution applicant. Then in another case, JR Agro Industries Private Limited versus RP Swadhisht Oil Private Limited. So in this case, National Company Law Appellate Tribunal NCLAT held that a company which is an associate company of a corporator would also be related party. Okay, suppose if any company is there which is undergoing already, which is in the process of insolvency. So if any associate company is there to this company, okay, so even this associate company is also considered to be related party. So that's why even this associate company cannot be a resolution applicant. Okay, that is the meaning of associate company. Next category of the person who is not eligible is discussed under section 29A clause B. Prospective resolution applicant is a willful defaulter. So here, what is the meaning of willful defaulter? Willful defaulter means any person who is unable to pay the debts. Okay, RBI is having certain criteria to declare a person as a willful defaulter. If any person is declared as a willful defaulter, then in such cases, such person is not eligible to be resolution applicant. So here, interestingly, in the case of Harkirat Singh Bedi versus the Oriental Bank of Commerce, in this case, NCLAT held that suppose if any person is declared to be willful defaulter, so under the legislation, such person can go to the court of law. Okay, so maybe he can go to the High Court or Supreme Court when any writ petition is pending before the court of law. So during the pendency, will he be considered to be willful defaulter or not? Okay, so the question mark is that when the pendency is there, will he be considered to be willful defaulter or not? So in this case, the court NCLAT held that so mere declaration as a willful defaulter will be sufficient. So even though there is a pendency is there, okay, so because until and unless the petition is disposed of or petition is decided, you cannot say whether such person is really a defaulter or not. But here, we are not here to decide whether such person is a willful defaulter or not. Okay. So if any person is declared to be willful defaulter, subsequently question can be raised before the court of law. Merely because if someone is declared to be willful defaulter, such person is not eligible to be resolution applicant under this clause. In another case, Sri Chamundi Mopeds Limited versus Church or South India Trust Association. In this case, Supreme Court held that mere stay of proceedings does not discharge or undo disqualification. So as already we have discussed, if RBI declares someone as a willful defaulter, that itself is sufficient. Okay, so maybe proceedings may be pending or the willful proceedings may be stayed by the court of law. Okay, so but it will not discharge or undo the disqualification under clause B of section 29A. Okay, then another category is non-performing asset. So any person, whoever is having non-performing asset or NPA, such person is not eligible to be resolution applicant. So under this clause we are having three categories. Okay, so who is not eligible? First category, at the time of submission of resolution plan, has an account of NPA. So if any person, here they are talking about the individual, if any person such NPA is there at the time of submission of resolution plan also, okay, then what is required? At least a period of 1 year has lapsed. So that means NPA is declared, okay, and 1 year, from the last 1 year, this is the NPA only. At least a period of 1 year has elapsed from the date of such classification till the date of commencement of corporate insolvency resolution process of the corporate debtor. So that means as an individual, if I want to file an application for resolution plan, or else if I want to submit the plan, okay, when I am not eligible, already 1 year back, okay, there is an NPA is there, still it is continuing, please remember. So 1 year back NPA is there and still it is continuing, and the NPA status is there when I am filing a application or when I am filing the resolution plan. So as on the date of submission of resolution plan, if there is any NPA is there as an individual, I am not eligible. Or second category, an account of corporate debtor under the management or control of such person classified as NPA. So I am having one company, okay, where such company is having one NPA, and this NPA is there from the last 1 year. So as on the date of submission of resolution plan, okay, so if this NPA is there, where in the company is having NPA, and on the company as a person I am having a control over the company. Okay, so here NPA belongs to the company. In the first category, NPA belongs to the person. Second category, NPA belongs to the company. And on the company, someone is having control. Okay, so someone is having control over the management of such company. Then this person, whoever is having control, even he is also not eligible. And third category, such person is a promoter. Suppose if any company is having NPA, okay, and this NPA is there from the last 1 year, okay, and if any person is a promoter of this company, then such promoter is also not eligible to be resolution applicant. So there are three categories: individual, any person who is he himself is having some NPA. So for these three categories, one common condition is that the NPA must be in existence from the last 1 year, and at the time of submission of resolution plan or CRP process, the NPA must be in existence. Okay, so first category, the person, that means the person he himself is having NPA. Okay, second category, the person. Second category, corporate debtor, where NPA is there, and any person who is having control over the management of such corporate person. Third category, any person who is a promoter of that corporate debtor. So corporate, that corporate entity. Okay, so in these three categories, okay, the person is not eligible to file or to submit the resolution plan. Let us discuss in detail. So in the case of ArcelorMittal case law, the Supreme Court held that they discussed in detail about the concept of management and control. Why? Because if you observe the clause, it is stated that any person who is having control over the management of the applicant, okay, then such person is not eligible to be resolution applicant. So that's why they have discussed in detail what is the meaning of control and management. So here the concept of control includes de jure control, de facto control also. Okay, and control includes only positive control. It is not a negative control. What is the meaning of negative control? Suppose if someone is able to stop a special resolution. Imagine someone is having 26%. So whenever if you want to pass a special resolution, you need to have 75%. So if someone is having 26%, obviously he will be in a position to stop the special resolution. So does it mean that he is having control? No. So it is a negative control. Why? Because he cannot take the decision, but he can stop the decision. Okay. So if any person is having negative control, okay, such control is not considered here. So control means only positive control. That means if any person is able to take the decision, okay, then only he is considered to be having control over the corporate, over the entity. Okay, so that is what we are supposed to consider here when you are defining the term control. In another case, la, Brijendra Kumar Mishra, RP of Lakeland Chemicals India Limited versus BK Mishra, RP of Lakeland Chemicals India Limited. So in this case, la, NCLT Mumbai bench held that the disqualification to be considered at the time of submission of resolution plan. So when we are talking about the disqualification must be there at the time of submission of resolution plan. So if the disqualification was there previously, then we don't consider. Okay, this disqualification must be there at the time. So what is important? The time, at the time of submission of resolution plan, the disqualification must be there. So in another case, la, Panch Tattva Promoters Private Limited versus GPT Steel Industries Limited. So in this case, la, NCLAT held that the resolution applicant shall be allowed by the COC shall not exceed 30 days, exceeding 30 days to make the payment of overdue amount. This extension is to be considered while calculating CRP period under section 12. Now let us discuss about this concept in detail. So if you observe section 30 subsection 4 and proviso 2 of the section 30, which provides that if any resolution applicant is disqualified under section 29A, okay, there is a concept or there is a provision is there where COC may allow such person to pay the amount, because when dues are there, overdues are there, then only such person is not eligible to submit the resolution plan. Then COC may allow him, first you pay the amount, then subsequently you can come back. Okay, so under section 30, this provision is there. Okay, so now COC allowed someone to pay the money. So when he is making the payment, he has to pay overdue amount, total overdue amount along with the interest. But please remember, COC can give the time up to 30 days only to repay the money. And one more thing that you have to consider is under section 12, there are time limitations are there. As already we have discussed in the previous classes, 180, 270, 330 days, like that, various time limitations are there. So under section 30, COC is having power to extend the time limitation or to give more time to the any resolution applicant, not more than 30 days. But please remember, this 30 days must be included. Okay, so this 30 days must be included while calculating the total number of days. Okay, so in no case the total number of days cannot be more than 330 days. Okay, so this point you have to consider. Okay, so there is one provision is there where if any resolution applicant is not eligible because of overdue amounts, then in such cases you may give time to the resolution applicant, you pay the money, then subsequently come back. But for this process, you cannot, the COC cannot give more than 30 days. Then next clause, conviction for an offense. So if any person is convicted for an offense, okay, then in such cases, such person is not eligible to be resolution applicant. So in the case of Reliance Steel India Private Limited versus Electro Steels India Limited. So in this case, NCLAT held that. So certain conditions were laid down. Okay, there shall be conviction. So if you want to apply this clause, that is clause D, okay, these conditions must be satisfied. There shall be conviction. And conviction should be for an offense which is punishable with imprisonment. So if conviction is not punishable with imprisonment, then this clause is not attracted. Okay, then sentence of imprisonment shall be for 2 or more years. Okay, so if these conditions are satisfied, these 3 conditions. So first one, there shall be conviction, and conviction shall be for an offense which is punishable with imprisonment. So imprisonment must be there, and such imprisonment shall be for more than 2 years. Okay, then if these 3 conditions are there, then such person is not eligible to be resolution applicant under clause D. Then under clause E, disqualified to act as a director under the Companies Act. So section 264 provides for disqualification of directors. So there are interesting case laws are there. Yashodhara Sharaf versus Shroff versus Union of India by the Karnataka High Court, and G Vasudevan versus Union of India. Okay, so the time will not be sufficient to discuss these cases in detail, but let us discuss in brief. Okay, under section 164, so which provides that if any company fails to file the financial statements for a continuous period of 2 or more years, then in such cases every director of such company is not eligible to act as a director in any other company. Okay, so this was questioned before the court of law on the ground of Article 14, Article 19 and Article 21 of the Constitution of India. Okay, constitutional validity of such provision was questioned. Why? Because if any company is a default, the section says that all the directors are not eligible to act as a director in any other company. And in all other companies, they are supposed to vacate the office. Okay, they are supposed to vacate the office except in the company where there is a default is there. So that means if Mr. X is a director of a company, there is a default is there in filing the financial statements, then Mr. X has to vacate office from all other companies other than the X company, other than a company. Okay, because someone should be there to who is responsible for compliances. So that's why other than this A company where where there is a default is there. So in all other companies he is supposed to vacate the office of directorship. Okay. So this was questioned before the court of law, and the court of law held that this is constitutionally valid. Okay. So anyway, so come back to our discussion. So if any person is disqualified to act as a director under the Companies Act, then such person cannot be resolution applicant under section 29A. Then next clause F, 29A, prohibited by SEBI from trading in securities or accessing the securities market. So in the case of ArcelorMittal case law, Supreme Court held that if any person is prohibited by the SEBI, so it is very simple. If any person is prohibited by the SEBI, then he is not eligible to submit the resolution plan. So maybe someone is prohibited by the SEBI because of violation of insider trading regulations, or maybe takeover code, maybe LODR regulations. Okay, so like there are so many regulations were there passed by the framed by the SEBI. So if any person violates those regulations, so under certain sections, SEBI is having power to prohibit such person from not accessing, or prohibit such person from accessing the market. Okay, so if any person is prohibited from accessing the market under SEBI Act or regulations made thereunder, then in such cases, such person is not eligible to be resolution applicant. Okay. Next clause G, person involved in a transaction that has been avoided under the tenets of IBC. Okay, so if a person has been a promoter or in the management or control of CD in which, okay, there are preferential transactions are there. Already we have discussed PU, EF. Okay, so if any preferential transactions, undervalue transaction, extortionate credit transactions or fraudulent transactions are there, then if any person is there in the management of such corporate data, then such person cannot be a resolution applicant. Okay, and in respect of which an order has been passed. Okay, already order has been passed by the tribunal NCLT that such person is ineligible to present the resolution plan. Okay, so if any PUEF transactions are there, so all the promoters of such corporate data will not be eligible, or will be not eligible to act as a resolution applicant. Okay, then another class, guarantor to the corporate debtor. So if any guarantor is there to the corporate debtor, because he is liable under the CRP process, so that's why the guarantor to a corporate debtor is not eligible to file a application for resolution plan. Okay, then clause I, subject to any disability corresponding to clauses A to H under any law. Okay, in any jurisdiction outside India. So in a jurisdiction outside India, so they may not have same provisions, but outside India, if they are having corresponding provisions, okay, more or less similar provisions are there. If someone is having disability outside India, that is any foreign national, then such person is not eligible to be a resolution applicant. Okay, next class has connected person. Okay, so if any person is connected person to the above categories, already we have discussed. Okay, such person is not eligible to be resolution applicant. Okay, so now let us discuss the role of resolution professional. Okay, so what he is expected to do during this process. Okay, so please remember whether RP is having power to decide who is not eligible. No, RP is not having power to decide. Okay, the role of RP, that is resolution professional, is only advisor. He is a facilitator. Okay, so he don't have the power to decide, or he don't have power to decide whether someone is a disqualified. Okay, so he has to prepare a note. Okay, so as already we have discussed in the previous classes, the resolution professional, when resolution application is received or resolution plans are received, he is supposed to do the due diligence. Okay, while doing the due diligence, he is supposed to verify all these things, and he is supposed to place it before the COC. Okay, so in the case of ArcelorMittal case law, the Supreme Court held that section 30 subsection 2 clause E does not empower RP to decide. Okay, who is supposed to decide whether someone is disqualified or not? It is COC who is supposed to decide whether a resolution applicant is disqualified or not. Okay, so in another case law, Everest Organics Limited versus Lisa Life Sciences Private Limited, NCLAT held that the RP cannot reject on the grounds of ineligibility. So RP is supposed to point out So while doing the due diligence, he is supposed to note down so and so person is not eligible, and he has to place it before the COC. As already we have discussed, so it is the responsibility of resolution professional to place all the resolution plans before the COC. Okay, so he is supposed to just highlight it. Okay, so whether someone is eligible or not eligible. Okay, so COC has to take the decision. Then please remember, once the COC take the decision, will it be final? No, it is not final. Okay, in the case of Raghavan Srinivas versus RS Doddabi Ragoda RP of Southern Batteries Private Limited. So in this case, NCLT Bengaluru bench, it was held that the decision of COC on ineligibility is not final. Okay, so any person who is agreed by the decision taken by the COC, he can go to the court of law. So that is always amenable to the judicial review. So even COC decision is also not final. And in another case, Bank of India versus Agnipa Energo Private Limited. So in this case, NCLT Guwahati bench, it was held that various COC found a prospective resolution applicant to be disqualified based on the misconception. Okay, so misconception of the facts. Okay, in such cases, fresh invitation for expression of interest may be directed. So there is a possibility. So based on the expression of interest, the COC found that someone is not eligible, but some defects are there in the facts. Okay, there is a misconception is there. Okay, in such cases, there is a possibility. COC, there is resolution professional. Again, they can invite the expression of interest. Okay, so they can go for public announcement. Again, it can be expression of interest can be directed once again. Okay. Then in another case, Navneet Jain versus Manoj Sehgal, NCLT held that the decision of the COC can be challenged post the decision of COC under section 30. So when you can challenge the decision, so RP is going to propose. Subsequently, COC is going to decide. So you cannot challenge before that. Okay, so even if you know the information that someone is not eligible, such person cannot challenge unless and until COC officially declares that so and so person is not eligible. Okay. So let us discuss applicability of section 29A to the schemes in liquidation and auction sales during the liquidation. So if any company is undergoing the liquidation, say the section 29 is applicable in that scenario, there is a question mark. Okay. So in the case of Arun Kumar Jagatramka case law, the Supreme Court held that section 29A applied to proceedings in liquidation as well. Okay, so even when the liquidation proceedings are going on, even there also section 29A will be applicable. Okay, so why? Because if you observe section 35 subsection 1 clause F, which mandates that the liquidator shall not sell immovable property or movable property, because when liquidator is appointed, he is going to realize the assets of the company. So when he is selling the immovable property or movable property, maybe through action sale. Okay, so in such cases, the liquidator is not supposed to sell this immovable or movable property to the person who is not eligible to be resolution applicant. Okay, so it was clearly provided under section 35 subsection 1. So section 29A is applicable not only during the CRP process but also liquidation process also. Okay, so you are going to discuss subsequently about the liquidation process in the subsequent lessons. Okay, then whether a scheme under section 230 can be proposed by any person who is not eligible. Okay, so it was held that a scheme under section 230 cannot be, okay, can only be proposed by a person who are not disqualified. Okay, so that means if any person is disqualified under section 29A, such person cannot propose a scheme because he is a person who is responsible for distress of the company. Okay, in the case of Atiyattam Prasad Singh, liquidator of SNS Diagnostics Limited versus Utsav Securities Private Limited, NCLT held that a person who is a non-executive independent director will not be disqualified. So if any person is a non-executive director, independent director of any corporate data, then such person will not be disqualified under section 29A. So in another case, Kanti Mohan Rastagi versus Red Brick Consulting Private Limited, NCLT held that the disqualification applies to sale and liquidation as well. So as already we have discussed in the previous slides, the disqualification is applicable to even liquidation process also. Whether is it applicable to MSME? Yes. So MSME, there is an exception is there, section 240, but such exception is applicable only in case of class C and class H. Okay, you are requested to refer class C and class H in the slides already, which is explained. So please remember, the exception given under section 240A is applicable only in case of class C and class H. So it is not applicable to other clauses. So that means section 29A shall not apply to resolution applicant in respect of corporate CRP process or pre-packaged insolvency process. Okay, so though you are MSME, exceptions are there, but only in case of class C and class H. Remaining clauses will be applicable as usually. Okay, so this is a special privilege available to the MSME that you have to remember. So in the case of Sharvana Global Holdings Limited versus Bafna Pharmaceuticals Limited, in this case, NCLAT held that the exemption is given from two clauses only. So it is not given totally, two clauses from section 29. Okay, section 29 A, C and 29 A clause H. So in another case, Mahalingam Suresh Kumar versus Mahalingam Suresh Kumar, liquidator of GB Raja Top Weaving Private Limited versus Officer of the Tax Recovery Officer, DAT Coimbatore. So in this case, NCLT Chennai bench held that in case of willful defaulter, exemption is not applicable because the exemption under section 240A is applicable only in case of C and H. So in case of willful defaulter, that is not in class C and H. So that's why that exemption is not applicable in case of willful defaulter. Let us recap what we have discussed today. Today, we have discussed about the concept of the person who is ineligible to act as a resolution applicant. Even in the previous session also, we have discussed the concept of person who is ineligible to act as a resolution applicant. Then we have discussed section 29A in detail. Then meaning of person and person acting jointly or in concert with such other person. Because if you observe section 29A, section 29A use the word person, person acting jointly and person acting in concert. So these three words used. So that's why we have discussed the meaning of person, person acting jointly and person in concert we have discussed. Then we have discussed about section 29A clause B, that is prospective resolution applicant is willful defaulter in accordance with the RBI guidelines. So if any person, if prospective resolution applicant is a willful defaulter, if any appeal is pending against the order given by the RBI, is he eligible to file an application or is he eligible to file a resolution plan? We have discussed that no, he is not eligible to file an application or file a resolution plan under this section. Then we have discussed about the scenario of non-performing asset, how to deal with the non-performing asset. Then conviction for an offense. So if any person is convicted for an offense, is he eligible? No, he is not eligible to act as a resolution applicant. Then if any person is disqualified to act as a director under the Companies Act, so is he eligible to be a resolution applicant? We have discussed that no, he is not eligible to be a resolution applicant under section 29A. Then under section 29A clause F, prohibited by the SEBI from trading in securities. So if any person is prohibited by the SEBI from trading in securities or accessing the securities market, then in such cases, such person is not eligible to act as a resolution applicant. Then we have discussed about the role of resolution professional in deciding whether any person is eligible or not. Then we have discussed about the applicability of section 29A to the scheme in liquidation and auction sales during the liquidation. Whether section 29A is applicable during the liquidation process also. So this question we have answered in this session. Then we have discussed about the section 29A, applicability of section 29A to the MSME. So whether to the MSME, because special privileges are there to the MSME. So that's why whether section 29A is applicable to the MSME or not, we have discussed in this lesson. So with this, we have completed the concept of person who is ineligible to act as a resolution applicant. Thank you.